This defence protects statements of opinion, or what are sometimes called value judgments. Someone sued for defamation will have a complete defence if they can establish that the first three criteria on the slide are met: that they have expressed an opinion, that the publication showed the basis for their opinion, and that the opinion could have been honestly held on the basis of the known facts at the time. In these circumstances, the defence can only be defeated if the claimant can establish that the defendant didn't genuinely hold that opinion, which is usually hard to do. The statement must be recognisable as an opinion to a person reading or hearing it. It cannot be a statement of fact. The statement should also indicate the facts on which the comment is based, and the defendant will have to prove that these facts are true. The defence cannot succeed if the opinion is based on false information. So if, for example, the comment was made that Mrs. Jones is one of the most unscrupulous businesswomen in the country, the same publication would need to set out the facts that support this allegation. For example, mistreatment of employees, misleading of consumers, dishonesty in business dealings, or whatever the facts were. To succeed in an honest opinion defence, it would be necessary for the publisher to establish that those factual allegations were true. The law recognises that there are certain situations when people should be able to speak freely without any fear of being successfully sued for libel. These situations are protected by a defence known as privilege. There are two types of privilege, absolute and qualified. Both provide important protections for free speech, but absolute privilege is a stronger defence than qualified privilege for reasons I will explain. Absolute privilege provides a complete defence, meaning that the person who made the statement cannot be liable regardless of whether it causes serious harm to reputation. If a statement is absolutely privileged, it doesn't matter whether the information is in fact false or whether the motive in publishing it was to harm someone's reputation. Absolute privilege applies to specific categories of statement which the law has recognised as requiring special protection. The slide gives some of the most common examples. For the purposes of this course, the most relevant situation in which absolute privilege applies is when reporting on judicial proceedings anywhere in the world, while they are happening or very shortly afterwards. It is permissible to report on what has been said in court, and these remarks may be defamatory. For example, a witness may make allegations against a person or company, and as long as such reports are fair, accurate, and contemporaneous, they will be protected by absolute privilege. The reporting should be balanced, and there should not be any substantial inaccuracies or omissions. It is important that any quotes taken from the proceedings are attributed. Absolute privilege might also be relevant where, for example, a staff member of a campaigning organisation gave evidence to a parliamentary select committee. If they made defamatory remarks about another person, those would be protected by absolute privilege in the same way as MPs' statements in the House of Commons are protected by absolute privilege. The qualified privilege defence protects statements where there is also a strong public interest in people being able to speak freely, without fear of being sued for libel. However, it is called qualified because it doesn't protect statements that have been made maliciously. Qualified privilege applies in two different types of situation. First, the qualified privilege defence protects statements where there is a common duty or interest in publication between the publisher and the recipient. For example, if an employee suspected a fellow employee of theft and reported it to the employer, that statement would be protected by qualified privilege. The same applies to a statement made at a public meeting where everyone concerned had a common interest in the topic under discussion. Employment references and credit checks are other examples of specific types of document protected by qualified privilege. In all of these situations, the public interest in freedom of expression is so strong that even false statements are protected, providing they have not been made maliciously. Secondly, Parliament has decided that publishing fair and accurate reports of certain kinds of proceedings should also attract qualified privilege, and some of these are very relevant to the work of NGOs and campaigning organisations. This slide shows the situations in which fair and accurate reports of certain kinds of proceedings anywhere in the world will be protected. This is important for NGOs because it allows them to rely on official proceedings or reports without having to establish that any defamatory allegations made in those proceedings are true, providing that their own report is a fair and accurate account of the proceedings. The full list of protected situations is set out in Schedule 1 to the Defamation Act 1996. So fair and accurate reports of proceedings in legislatures or courts of law or public inquiries or international organisations or international conferences are all protected. However, as with the honest opinion defence, the qualified privilege defence can be defeated if the claimant can show that the defendant published the defamatory allegation maliciously, for an improper purpose, or without any genuine belief in its truth. So care should be taken when reporting wild allegations that are not credible, even if they come from a parliament or a court, for example. Many individuals and organisations run websites which provide a platform for people to post material. Posts may be in response to an article posted by the operator of the website. For instance, a campaigning organisation might put up articles on its website with a comments function. Alternatively, an organisation campaigning for constitutional reform might host a blog to which anyone can contribute posts. Information posted by third parties may be defamatory. A website operator may be sued for defamation for statements posted on their site by third parties if a claimant cannot identify the person who posted the statement. But website operators have a complete defence against such claims if certain criteria are met. First, the website operator must not have posted the statement that is said to be defamatory. And second, if the website operator has been given notice of the statement that is said to be defamatory, it must have responded promptly. The response required varies depending on whether it is possible to contact and get a response from the original poster. Generally, a website operator will need to have either contacted the original poster and/or taken down the statement within 48 hours.